Status in OTF. The affidavit further stated that CW1 provided information about shootings and other overt actions that OTF members and associates took to commit violence on behalf of OTF. The affidavit then provided a specific example of racketeering activity in which defendant Banks and other OTF members participated, specifically an Atlanta robbery turned shooting in which defendant Banks and Davon Bennett were both charged with attempted murder and participation in criminal street gang activity. Following the murder of OTF member Davon Bennett, aka King Von, the affidavit further disclosed that CW1 knew the defendant Banks placed other monetary bounties for the murder of people with whom defendant Banks was feuding, including 6 other individuals. The affidavit also listed significant evidence corroborating CW1's account of defendant Banks' involvement in SR's murder. Lil Durk just got hit with a 12-page document. Don't worry, there's 3 other that dropped last night, but the most important one we're going to get through because it's 12 pages as well. So we're going to get through each and every freaking page. Hit that like button down so we can force the conversation. Let your thoughts be heard. But with no further ado, let's get into it. The feds firing back at Lil Durk. And let me tell you, they came to play ball. Let's go. As you can see, we have it all set up for y'all. Attorney for Plaintiff, United States of America, United States District Court for the Central District of California, USA versus Durk Banks. Government's opposition to defendant Banks' motion to suppress evidence and request for a Franks v. Delaware hearing. Hearing date November 18, 2025. Y'all got it at 1:30 p.m. Courtroom of the Honorable Michael W. Fitzgerald. Let me know if y'all want to deep dive on this judge in particular, because y'all know we like doing stuff like that. Plaintiff, United States of America, by and through its counsel of record and the acting United States Attorney for the Central District of California, Assistant United States Attorneys Ian and George and Daniel hereby files its opposition to defendant Banks' motion to suppress evidence and request for a Franks v. Delaware hearing, docket number 259. The opposition is based upon the attached memorandum of points and authorities, the files and records in this case, and such further evidence and argument as the court may permit, dated October 27, 2025. And y'all see, we got all those good people right here. Y'all ready for this? So basically what they're doing is they're setting up the tone, and they're basically saying, yo, even if he did this wrong, meaning the agent did it wrong, bruh, it's still a good faith. Meaning my intent was not negative. See, Durk's whole entire thing is you guys misled the public. You guys misled the courts. You misled the jurors. This is what y'all did. My stuff didn't come like how y'all said. And they're saying, yeah, it did. So don't sit up here and play them games, bro. Our affidavits, everything that we want right, or everything we believe is right, is actually right. So we're going to see how they walk it on down, because as it goes right now, y'all know we ain't believing the feds. Never worry. But it might get a little interesting. Let's go. Memorandum of points and authorities. Defendant Banks moves to suppress evidence seized from 2 accounts pursuant to federal search warrants. 1, the X account at Lil Durk, the Banks X account, and 2, the Durkio iCloud.com iCloud account, the Banks iCloud account. As in prior filings, defendant's motion focuses on rap lyrics contained in Wonderful Wayne and Jackie Boy. Defendant does not dispute that he rapped those lyrics or that his lyrics are about greenlighting a murder of a rival. Instead, defendant asserts the lyrics were written 7 months before SR's killing, and thus the government's mere inclusion of the lyrics in a search warrant affidavit amounts to a material falsity requiring a Franks hearing. This argument is meritless for several reasons. First, defendant has failed to identify any false statement or information actually contained in the affidavit. Apparently recognizing this, defendant attempts to manufacture a misrepresentation by citing to an allegation about the lyrics contained in prior non-operative iteration of the indictment. See motion at 2 through 3, and then asks the court to interpose falsity within the affidavit where there is none. But other than defendant's claim the warrants contain demonstrably false statements and/or omissions, the motion is devoid of evidence or facts that show the following. And you can see right here it says, as defendant notes in his motion, the affidavit filed in support of the warrants are substantially similar, and thus the government will generally refer to the affidavits as the affidavit in this filing. For Exhibit A, defendant filed a version of the affidavit that contains a redacted footnote, example A at 6 and 3. The footnote, however, is substantially similar to footnote 3 in Exhibit B. Factual allegation is anything but true. In December 2022, Banks was featured on a song called Wonderful Wayne and Jackie Boy. In the song, Banks rapped that it's effed up that I'd rather get revenge instead of millions. Told me that they got an addy, go, go. Got a location, go, go. Green light, go, 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 go. Look on the news and see your son screaming, no, no, pussy. Notably, following SR's murder on October 19, 2022, bystander video captured TB screaming, no, no, when he saw SR's body pulled from the Escalade. Affidavit at 13F, noting about this allegation is false or misleading. Indeed, defendant does not dispute he was featured in the song or that it was released 4 months after SR's murder. Defendant does not dispute his song explicitly referencing seeking revenge over profits and greenlighting violence after learning the location of a rival. And defendant does not dispute the lyrics are similar to a publicized video of defendant rival TB screaming no, no while watching sheriff's deputies remove SR's dead body from a vehicle on the day he was murdered. Nor can he. Simply put, these factual allegations are true, not false as defendant claims. Defendant's omission theory similarly lacks merit, citing to an affidavit found a sound engineer that defendant Banks filed earlier in this case. Defendant asserts the affidavit recklessly or intentionally failed to state that defendant wrote his lyrics before SR's murder, but even assuming this is true, the government could, and we see right here, the declaration was filed approximately 7 months after the government obtained the warrants at issue. Docket 111, notably, defendant failed to comply with this district's local rules in filing this motion to suppress, which requires a declaration on behalf of the defendant, setting forth all facts then known upon which it is contended the motion should be granted. LCR 12 through 1, notwithstanding defendant's lack of compliance, the government reserves the right to cross-examine any declarant in connection with defendant's motion, LCR 12 through 1-3. Now, the way that they chopping this all up, they basically said, bruh, this ain't just lyrics. We don't give a damn when it dropped. This ain't just lyrics. It don't matter what the hell Lil Durk tried to say. It don't matter what he tried to do. Oh, you trying to peep over there? Okay, all right. And yeah, but that's a lie. That's a lie. My lyrics don't mean none of that. Yeah. But it's like, no. This shit lines up, this lines up, and this lines up. You may have written it this way, but you already knew what you was already planning. Do y'all believe that theory so far? Yeah, I didn't think so. Not have purposefully or recklessly omitted a fact it did not know. And even if this standard was met, it isn't. Defendant's argument also fails because it hinges on the premise that his lyrics are only relevant to the probable cause determination if he wrote them after SR's murder. Not so. Defendant's lyrics, i.e. admissions about ordering a hit and seeking revenge, show defendant's modus operandi and corroborate CW1's account that defendant ordered and financed the Los Angeles murder as set forth in the affidavit. Although the court can deny defendant's motion on the merits, it need not do so here. As discussed further below, defendant has standing only to challenge the seizure of evidence from the accounts that belong to him, two accounts at issue. Because the government does not intend to introduce evidence seized from those accounts at trial, the government respectfully requests that the court deny the motion as moot. Basically saying, we ain't see nothing that we like, so we ain't even finna bring that up. One, argument. A, defendant's motion is moot. The Fourth Amendment guarantees the right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Smith versus Maryland. The capacity to claim the protection of the Fourth Amendment depends upon whether the person who claims the protection has a legitimate expectation of privacy in the invaded place. Rockets versus Illinois. It is well settled that a defendant does not have a reasonable expectation of privacy in someone else's email and/or online account. See Alderman versus United States. Fourth Amendment rights are personal rights which, like some other constitutional rights, may not be vicariously asserted. Noting that co-conspirators and co-defendants have been accorded no special Fourth Amendment standing. United States versus Omidi. Chief District Judge G ruling that defendant lacks standing to challenge the warrant as to the 3 Gmail accounts that do not belong to him. United States versus Lustiak. A person has no expectation of privacy in another person's email account. United States versus Nazimdade. That's Persian as hell, bruh. Here, the government has reviewed the evidence seized from the bank's X and iCloud accounts and determined that it will not seek to admit it in its case in chief. Any such evidence defendant has failed to submit a declaration alleging a possessory interest in the other iCloud accounts searched pursuant to the warrant at issue, nor can he because they do not belong to him, and thus defendant does not have standing to challenge the search of those accounts. Defendant's motion is therefore moot. United States versus Kerry. Affirming district court's determination that so payment history, IP logs, the money from Chicago to LA, bruh, they basically said, yeah, we got it in certain accounts, and this is what led us here. It's not like we just randomly chose and randomly selected. Nah, bruh. These little things right here, this led us to right here. So you can't sit up here and say, we just basically messing up and we just coming after you, winning all candor. Nah, that's not what it is, bro. We got the logs. We got everything. We gonna introduce you Illinois versus Gates. So it is what it is on that part. I ain't gonna hold you. They doing their job as far as what they're supposed to do. Just gonna keep it authentic with y'all. But let's see. Defendant's motion to suppress was moot where government informed court it was not introducing the seized evidence at trial. Even if defendant's motion was not moot, the affidavit contains significant evidence establishing probable cause to search the bank's X account and the bank's iCloud account. Although the court need not reach the merits, the affidavit had ample probable cause to search both of defendant's accounts. Probable cause is not a high bar. Cayley versus United States. Rather, probable cause is only a fair probability that contraband or evidence of a crime will be found in a particular place. Illinois versus Gates. Whether probable cause exists is based on the totality of the circumstances known to the officers. United States versus Smith. Moreover, the law enforcement may draw upon their experience and expertise in determining the existence of probable cause. United States versus Garza. The experience of a trained law enforcement agent is entitled to consideration in determining whether there was probable cause. United States versus Rios. Both search warrants authorize law enforcement to search for evidence of various offenses, including violations of murder for hire and conspiracy to commit murder for hire, racketeer influence and corrupt organizations, Rico, conspiracy and the violent crime in aid of racketeering, Vicar statute. I ain't finna read that Roman numeral so I can butcher that one. That's probably, what is that, a V? So 7? Yeah. Okay, yeah. Each warrant was supported by a substantially similar 35-page sworn affidavit from an FBI special agent. Basically said, oh yeah, by expertise, I'm good enough to go. Man, bullshit, but whatever. The affidavit detailed a special agent's 14 years of training and experience in murder and other violent crime investigations. ID at 3 through 4. The affidavit set forth specific facts establishing that Chicago-based hitmen traveled from Los Angeles to murder one of defendant banks and OTF rivals, and that defendant banks ordered and financed the murder plot. Among the evidence referenced in the affidavit is information provided by, y'all wonder who this is, huh? Based on information from CW1 and open source reporting, the affidavit explains that defendant banks placed a bounty on TB's life. Like, come on, bro. Y'all ever see this part right here? The defendant placed on rivals is irrelevant and was included in the affidavit to portray defendant Banks as a violent individual, an effort to prejudice. The reviewing judge motion at 8, the defendant confuses the charges that were later brought in the indictment, murder for hire and stalking resulting in death, with the broader subject offense listed in the warrant, which include violations of Vicar and Rico statutes. Defendants linked to other racketeering activities, included the 2019 shooting, is directly relevant to the probable cause analysis. So they're basically using the damn shooting that happened in front of that college, but don't realize that everybody except Lil Durk is dead. Wait, what? So a CW is a cooperating witness, and the cooperating witness basically says, hey, bro, I got the receipts, I got the telly, bruh, I got text messages, I got direct info from Durk basically saying, bruh, let's keep on sliding, let's keep King Von name alive, bruh. We finna go ahead and drop more hits on more hits on more hits on more hits. Bruh, this what it's all about. Durk over here playing a role, but I really know Durk, and I'm telling you, Durk just went ahead and did this and did that and did this and did that. And you know what I got? I got the text and I got everything to prove it, bro, from the fights and everything. Basically, I'm the one who told y'all what to look for, how to look for it, and who to look for. This is allegedly the main person who set all of this up from what it looked like. It looked like this the person who told y'all, hey, yeah, Durk and them, you know, Durk and them, bruh, they went, they killed Quando Rondo. And I know. You want to know how I know? Okay. On this day, they flew in. This the hotel they stayed at. This the store they went to. Well, not the store, but this the car that they got. This is that. Y'all can put together all the pieces from there. I gave y'all what they did, who they did it with, what to look out for, who to look out for, and I gave y'all the names. So this really looked like somebody probably got arrested and basically ran their mouth like, all right, y'all got me. But what kind of deal can we work out? Following the murder of OTF member Davon Bennett, aka King Von, the affidavit further disclosed that CW1 knew that defendant Banks placed other monetary bounties for the murder of people with whom defendant Banks was feuding, including 6 other individuals. The affidavit also listed significant evidence corroborating CW1's account of defendant Banks' involvement in SR's murder. Specifically, according to bank and flight records, an associate of defendant Banks coordinated and paid for 5 of the co-conspirators to fly in from Southern California using credit card linked to defendant Banks in OTF. Motion X at 9. And that's probably going to be about, we just going to leave that be. And just like the funding for the hitman's flights, records also showed that defendant Banks' credit card was used to purchase the hitman's hotel room the night before the murder. See, and remember what I told y'all about the Bezu stuff? But whatever. To establish probable cause to search for evidence related to violations of the Rico and Vicar statutes. The affidavit also contains information about OTF's structure and history of violence. Specifically, based on the FBI special agent's review of law enforcement reports, conversations with other law enforcement agents, and conversations with CW1, the affidavit states that in addition to OTF's status as a rap collective, OTF also acts as an association in fact of individuals who engage in violence, including murder and assault, at the direction of defendant Banks and to maintain their status in OTF. The affidavit further stated that CW1 provided information about shootings and other overt actions that OTF members and associates took to commit violence on behalf of OTF. The affidavit then provided a specific example of racketeering activity in which defendant Banks and other OTF members participated, specifically in Atlanta robbery turned shooting, in which defendant Banks and Davon Bennett were both charged with attempted murder and participation in criminal street gang activity. Lastly, the affidavit contained detailed opinions based on the special agent's training and experience regarding the behavior of those involved in the murder for hire and/or racketeering offenses, and that evidence related to those offenses was likely to be found in the digital accounts to be searched. The special agent opined that digital devices and/or social media accounts often contain gang members or racketeering associates' correspondence, including text, audio, and video messages between associates, as well as items and paraphernalia sufficient to show gang organization and membership. The special agent also opined that both hitmen and their contractors maintain materials about their intended victim in digital devices, including details/communications about the whereabouts of the victim and the motive behind it. Finally, the affidavit explained that X allows users to communicate with other individuals over the platform by exchanging private messages, including photos, videos, links, and text messages. Likewise, the special agent explained that Apple's iCloud is a file hosting, storage, and sharing service that can, among other things, contain a user's text messages, photos, videos, contacts, call history, emails, and other documents such as. They saying basically, we might have did too much, but shit, we did it by the book. Good faith doctrine still exists. Yeah, we might have, OD'd a little bit, but hey, player, we still did by the rules. The rules actually allow us to do this. Bruh, welcome to 2025. Everything digital is at play. But I don't know. They might be able to argue that one because we just seen something similar like that just happen in the YNW Melly case. If he goes back, Drew goes back, and he taps the shoulder of the lady, I can't think of her name, it's like Carrie Holt or whatever. If he taps her, and if those little here's and there's that they had, as far as the doggone messages, he might be able to slide that. But the pushback would be, bruh, it's Rico. Rico is far exceeded. It gives the FBI damn near superpowers. So that would be the one thing that I think he wouldn't be able to win in on, is because it's a doggone Rico. Just gonna be fair. Let's see. Spreadsheets as well as backups of a user's digital devices, e.g. a cell phone that contains a user's text messages and photos taken together. The specific facts set forth in the affidavit and the FBI special agent's training experience provide more than ample probable cause to search defendant banks' two accounts at issue. United States versus Ocampo. Required only a reasonable nexus between the activities supporting probable cause and the locations to be searched, and that a magistrate may rely on the conclusions of experienced police officers regarding where evidence is likely to be found. United States versus Rubio, explaining for a RICO search warrant, any evidence is relevant to prove any element of the RICO offense is potentially seizable, including evidence of association and of the existence of enterprise and evidence of the pattern of racketeering activity. United States versus Pelio, rejecting argument that an iCloud account is too broad a place to be searched because the law does not require warrants to specify rooms in a house, nor do we require warrants to specify files on a computer. His motion should therefore be denied. The case cited by defendant, United States versus Grant, is not on point. The case involved the search of the home belonging to the father of two gang members, one of whom was believed to be connected to a murder. 9 months before the search, the court found that the affidavit provided no evidence that the father had any connection to the murder at issue, or that either of his sons had left the murder weapon at the home. Those facts are not analogous to the affidavit at issue in the case, which sets forth the details of murder, the defendant's travel to California to commit the murder, defendant bank's connection, the accounts. I'm assuming it's supposed to be to the account search, but whatever. In the defendant bank's connection, the accounts to be searched, Grant is wholly inappropriate. Conclusion. For the foregoing reasons, the government respectfully requests that this court deny defendant's motion to suppress evidence. Feds is basically saying, bruh, this don't even meet legally the Frank bar here anyway. Throw this shit out, bruh. Y'all ain't even applying the right pressure. Y'all putting in the wrong things. Bruh, get him up out of here, homie. Nah, brother. He gotta go. Hell nah. Durk is wrong. Drew wrong. The whole little team is wrong. Y'all using the wrong stuff. Who the hell y'all thought y'all was? I ain't gonna hold you. The feds struck back real proper like. But here's one thing. Y'all dropped this in the middle of the night so that y'all can wake up and leave them a little bit frantic. Y'all gotta understand, bro. We're heading into November. They got 2 months to battle it on out. And I ain't gonna hold you. The other papers that we gonna read later on, or probably post on the Reloaded channel, make sure you hit that Reloaded channel. Ceddy Nash Reloaded. Bruh, I'm telling you, this is a real fight on their hands. The feds, they fighting, bruh. They not playing at all. So I ain't gonna hold you. It get real dark. What that man say? Crazy, scary, spooky, hilarious.
Hey, yo, you. Can you subscribe and turn on that bell too? Because when you do, you're helping unbiased, independent news.
I just personally find it interesting that basically whoever CW1 is essentially the person who put it all together. There's always these theories that get floated around, right? Like this person is this person is that. What you're doing is going to lead to this, and what you're doing is going to lead to that, right? The charges on Lil Durk, as far as Durk and King Von and Hella Benz and Bezul, which is crazy because Durk is the only one that's alive out of that. That's really like throwing my effing mind off, bro. I ain't gonna hold you. But yeah. So that's why it's like when y'all say certain things, y'all do know shit get recorded, right? So imagine everybody that called Lil Durk a snitch in the shooting that happened. You do realize that his admission, right? His admission that these individuals did this would have just came up now. It would have said, and defendant banks corroborated this story that this, and this happened. So there's that part. But here's the worst thing about all of this shit. They're saying we built this case based off of a cooperating witness and a couple of police officers who supposedly have knowledge of all of this shit, which means this case isn't going to last no longer than probably a week and a half. At that, they're going to have to try to bury Lil Durk's character and other things that's allegedly associated with him. The reason why they're bringing in all of this shit is to paint a picture about him. But the problem is the other states, Illinois has not charged Lil Durk on the shooting that happened in Chicago that they say the dudes basically slid for his brother. Lil Durk's ability to be charged in Georgia for the shooting that happened at the college basically died out too because they didn't have evidence because he didn't do it. That's number one. Number two, and this is the biggest thing. What the hell did that witness do to get put in position of all of this shit? That means that witness probably was on that drill. That witness has to be so close to everybody that they already know. Everybody involved in this case has to know who this person is already. So it just is what it is, man. But the other stuff that got filed, we'll take care of that on the Reloaded page. So type in Ceddy Nash Reloaded and that'll get you there. But click right here to get caught up on the last day almost of the Julio Fulio stalking and texting and telling, dropping location trial. Because this right here, I ain't gonna hold you. Today is gonna be a crazy day. I can smell it. The nose knows. But subscribe, turn the bell to notified, share to keep your people aware. Win one of these. We are 36,000 subs away from this giveaway. Make sure you comment your thoughts today. Click right here for the playlist, and I'll catch y'all in the next one.